This is the most exciting part about the program, where you get to hear the lawyer for a half hour. So after Sam's comments and others, I completely understand that. I'm trying to keep legal jargon out of this. I apologize. There may be a couple of terms along the way where that's unavoidable, and there's certain, I'll assume that there's some understanding of what I'm saying, but if that's not the case, after the fact, I'll be around for questions or whatever. Oops, am I doing this? You can see who the technologist in the room is, sir. Oops. Okay.
On the right.
Okay, why don't we'll just skip through.
Right there on the right.
There we go. Okay. Just very briefly about me. So I chair our business law group at Wilson Sonsini. I spend a lot of my time representing very large companies in exit strategies. I represented Business Objects last year, and Redback and Comag, and I do a lot of that. But I purposefully spend about 60% of my time on startups, and frankly, a lot of the companies that I work with on successful end strategies were with us from the very beginning. A lot of them we work with from the time of their business plans. And I thought, in terms of with the time we have, the most effective way I could talk about strategizing early on for entrepreneurs is to focus on the 4 basic questions that we work with our clients to think about from day one. And these questions roll through the entire history of the company, and a lot of decisions regarding these questions are made very early on, and you live with those decisions all the way through. We're all focused on companies, as David talked about. They're going to be very quick exit strategies. But believe it or not, the average time from the time a company has started these days until the time of a successful M&A deal or IPO transaction is 7 years. I mean, that's the average. There are companies that are very successful that go far beyond that. And a lot of the key decisions that companies make regarding ownership of the company, decisions that affect value at the end of the day, are made extremely early in the company's history. You don't often focus on the context of the endpoint, which may be years away, particularly if you're not an expert or in the business about worrying about these things. But I assure you that your investors are in that business, and so it's worth focusing on these. So let me get to what those questions are. I'm going to talk about questions surrounding who owns the equity of the company, who owns the technology of the company, who controls the company, and how are proceeds, frankly, divvied up at the end of the company's history in terms of a liquidity event. And by liquidity event, in this context, that's really legal jargon for an M&A transaction or a sale of the company. So, and again, I'm going to try to come at this from the vantage point of the young entrepreneur. At the end of the day, and the valley is strewn with sad stories that go the other way. After all of your hard work and after all of your multiple rounds of financing, if indeed that's the way the company plays out, you want to have as much value as you can at the end of the process in terms of cashing out on your stock, et cetera. And a lot of the decisions you make early on will have ramifications as to how much value you can see on the back end. The first point I'll make, consider vesting. It's fairly well understood that VCs will insist upon the founders that there be some restrictions on their stock that lapse over time. That's vesting. What's less understood is at the time that you're forming your company, as between the founders themselves, it's extremely useful to think about vesting provisions even pre-money financing. And the reason for that is there is a prevalency, or it often happens, where the initial deck of founders, the 2 or 3 people that found the company, one or the other will become either dissatisfied or want to move on, et cetera. In the absence of vesting provisions, they walk away with their stock free and clear. So the remaining founders, who may work for years to build up value, may be in a position where they find that a disproportionate amount of the benefits of what they do will go to one of the initial founders. And this happens all the time. I mean, for example, I represented YouTube. from the beginning, and they have two founders that are extremely well known. What's less well known is they had a third founder, and he was there for a few months and left. So this comes up a lot. It's not something that's focused on, and it has a lot of ramifications in terms of how ownership interests are divvied up at the end. No oral promises. I've done over 50 IPOs in my lifetime on both the investor side and the company side. 10% of the deals that I've done in registrations, we've gotten a lawsuit filed from somebody who said, I am the long-lost founder. I was there at the beginning, all these promises were made, I was told I'd own 20% of the stock, I hear you're going public, and gee, I haven't seen my share certificate. That can put a lot of gum in the works of offerings, both public and M&A deals. And you can really go sideways over that. So I would just caution you that at the time that you're talking to people as you're forming the company, and these things tend to be really informal, that you memorialize either through emails to yourself or memos where those things end up, to avoid trouble down the line. Because I got to tell you, when these suits are filed, they're basically frivolous hold-up suits, but there's always a little bit of smoke there. The people did meet with the founders. There were some discussions about their involvement in the company. There may even have been stock packages discussed, and at the end of the day, it didn't work out. But in the absence of memorializing that, it is sort of a, your word against their word situation. Related to that, we say no napkin promises. I should probably update that to say no email promises. Again, really early in the company's history, I completely second the notion, I think Sam put it out there, about not spending legal fees where you don't need to spend them. And companies rightfully are very conservative about that. But particularly in the early tenure of the company, it can be quite seductive to talk to a big name company. You go out to the lunch, you have the dinner, you have the conference room stuff brought in or whatever. And things are going so swimmingly that you think you can do things on a handshake basis or with a minimum of documentation. And I have 40 full-time IP litigators that are kept very busy at our firm trying to unravel promises that were made on the basis of very informal communication, whether it be by email or otherwise. So I caution you about that, particularly where it involves things as key as revenue streams for the company or royalties, and I'll kind of get into that a little more in a minute. The last point I'll make quickly about ownership of the company, again, Sam did a good job of really hitting a lot of the points that you'll see in a term sheet. What I would talk about here for just a moment is, as you know, preferred, when the VCs come in or the outside investors, they'll typically get preferred stock. Founders and employees will typically have common stock. You can look at the relative percentage interest vis-a-vis the two and kind of get an idea about control, but that doesn't really end the story. The preferred stock is always convertible into common stock, initially on a one-to-one basis. There are contractual terms that are negotiated in your Series A financing that have provisions that say if you sell stock, for example, below the price that you sold it in the Series A round, their conversion ratio adjusts to something better than one-to-one. And there's all these complicated formulas, broad-based weighted anti-dilution, narrow-based weighted anti-dilution, ratchets, etc. The point to understand is those get negotiated very early on, and once they're set at the time of the Series A financing, you can go through multiple rounds of financing, and you're never going to negotiate a better deal than the one that you subscribe to early on. So that can have a key impact on the ownership as well. Who owns the technology? So once you get through thinking through the ownership of the company, which is key, you then need to think about, well, what is it that the company actually owns? And in terms of diligence from investors, the key due diligence point is always surrounding the technology. I'll point out, first of all, the importance of confidentiality and assignment agreements. These are very basic agreements that you should have every one of your employees sign up to when they join your company that basically say they're not bringing any technology into the company that they own outright, and anything they work on with regard to the company is owned by the company. this is not an area where outside counsel will monitor the company closely to see that everybody signs one of these things up. But I got to tell you, if one falls through the cracks and a disgruntled employee leaves the company without having signed one, it can be a problem. The former employer, knowing where your employees come from, oftentimes they'll come from a competitor. This is not only a startup problem. This happens at the very mature company level. There have been real publicized cases of key executives at Microsoft going to Google, for example, in recent years, and Steve Ballmer's upset and written letters to the company saying, I don't see how this guy can move 1 inch in any direction at your company without violating our technology and his knowledge of it. So understanding where your employees come from, what the story is with them. There are legal strategies around that can really help protect the company as well, and it's worth focusing on as you build out your company. The Genentech Material Transfer Agreement, this is another horror story from our past where, again, we represent a biotech company which is very successful, subsequently went public and did very well. Very early in the company's history, they entered into sort of a joint venture agreement with Genentech, and everybody understood that this should be in writing. But they didn't want to hire, or spend the money on the legal fees. They did a one-page agreement internally, and buried in a relatively innocuous paragraph was a sentence that said any Genentech tools used in any development efforts under this agreement, the resulting fruits of that are owned by Genentech. That sentence surfaced, a couple of years later, and our client, in this case the biotech company, said, oh my goodness, we have to clarify that. Of course, everybody understands that that wasn't what was intended here. They went back to Genentech, and, guess what? Genentech said, seems pretty clear to us. So this biotech company had to expend tremendous resources, change their strategy to make sure anything they developed had nothing to do with Genentech tools, et cetera. And, they were able to successfully do that, but it just, on the basis of one sentence, really created a lot of issues for them. So the point here is that, particularly in areas of technology, the words do matter, and we have another 60 lawyers in our technology transactions group that do nothing but negotiate IP agreements. And believe me, there's a vernacular and a whole different language in that sphere that I don't, profess to understand because I don't work in it day to day. But in terms of running agreements by lawyers, et cetera, in this area, it's money really well spent and time well taken. Exclusive license, I'll just say very briefly on that again, anytime there's something that says the word exclusive in a technology agreement that, and the exclusive is on your end that you're giving away, be extremely wary. Even if you think that it's in an area that the company has no designs of ever getting into, again, the words surrounding what that exclusive provision means are very legalistically driven by case law, et cetera, and it can really impact what you think you own going forward when you try to expand your use of the technology. Final point on who owns the technology, narrow the risk of IP exposure. The point here is the one that was made earlier that, you shouldn't hold up your financing or your business plan or anything else until such time as your IP is 100% nailed down in terms of ownership, et cetera, because the answer is it never will be. Again, I can use a YouTube example in the digital media space. In the time getting that company funded, everybody knew that this was a new area that hadn't been well vetted in the legal community. The copyright issues surrounding the loops that would be posted on the site and what their obligations were to monitor that, et cetera. That's in the courts today, and everybody understood that that would be the case. But the point was the company, did a lot of work along with their investor Sequoia at that time in terms of really understanding what the parameters of the issues were and where they could take comfort and where they couldn't, and where they knew they were stepping up the risk and where they weren't. So really understanding kind of, the box that your IP sits in is really important in terms of valuation of the company and frankly, attracting capital. Third question, who controls the company? Well, obviously, the board of directors is a good place to start there. And, as was alluded to earlier, the key thing in terms of having a majority control of the board. But really, the issue doesn't end there, and I'll talk more about that in a second. But I wanted to touch briefly upon not only the quantitative factors regarding board representation, but the qualitative. Who you appoint to the board, including in the board seats that are allocated to you, perhaps it's a common investor or the entrepreneur. Directors, unlike officers and employees of the company, do not serve at the discretion of the board of directors. You cannot fire a director. The only way to remove a director is through action by shareholders. I have a very successful private company that's been around for 10 years up in San Francisco. Post $100 million a year in revenues. They are very profitable. I think that is a black mark against them and why they haven't done an offering or something for 11 years. But they had an ex-CEO on the board, kind of a turnaround guy that was brought in at a time the company was struggling. And he did a decent job turning around the company for 2 or 3 years and getting them off life support. But as a lot of these people can tend to be, he was a little abrasive, and at a certain point in time wasn't getting along with the other employees that were under him, and the board fired him. They terminated him. And they frankly did this without our sort of input. They went ahead and did it. Well, it turns out that this guy, through an internal counsel of the company, had negotiated his agreements. He took exception to his termination, sued the company. It took 3 years to get it through a jury trial, which just ended last year. But the point I want to make is they, of course, asked him to step off the board. And he said, no, I'm not going to step off the board. It is difficult under law to get a person off the board. I'll leave it to that, particularly if they own, as a person who's been a CEO for a few years would tend to own a fair amount of stock. Under cumulative voting rights and other protections for minority shareholders in California, you can't get them off the board. So bottom line is, here's a guy who's suing the company, his fellow directors, et cetera, and he had to be invited into the board meetings, and it was really, really tough. So be sure that the people you have on the board are the people you want to have on the board indefinitely. The shareholders. Some of this was alluded to previously. I'll just make the brief point, I think Sam made it as well, that when you look at your term sheet and you see the relative ownership interest between the preferred stock and the common stock, the optionees and the option plans set aside, it can be 10%, it can be 12%. It's usually put in the column of common stock ownership. And it's really not true. The only people that have a right to vote are outstanding shareholders. And optionees, first of all, you have to grant the option to the optionee. The option has to vest, and the optionee has to exercise it, which they typically do close to a liquidity event so that they're not putting cash out of their pocket for something that they can't sell for a while. So all of that has to happen before they have a voting ownership interest. So as a result, the preferred shareholders for a long time, until that plan plays itself out, will have an interest greater than it may look on the term sheet that they have with respect to controlling voting amongst the shareholding class. 2115 of the California Corporations Code, I'll just briefly allude to this. Most corporations these days go into Delaware. There are certain protections alluded to resident companies in California for minority shareholders and classes of stock, the most prevalent of which is in the context of an acquisition. If you're a Delaware company, you don't need the separate vote of the preferred shareholders and the common shareholders. Everybody votes together. In California, that's different, and you can get dragged, and you do get dragged back into California for those types of issues. So there are some built-in controls that protect the minority on that. Final point I'll make on control of the company, however, irrespective of those provisions, and irrespective of what your board membership is, and irrespective of the fact that the preferred owns a minority of the outstanding shares, in every deal, beginning with your Series A transaction with outside investors, there's going to be negotiated what are called protective provisions, which are contractual provisions that say, irrespective of what the law, says in terms of a majority of the board being able to control 99% of the decisions of the company, you have to come back and get unanimous approval of the minority, 2 out of 5 members on the board say, or you have to go back to the preferred shareholders on basic questions of corporate governance, even though you're not otherwise required to do so under law. So these protective provisions can be quite confining on a company. They can say things such as you can't increase the size of your option plan without going back and getting a preferred stockholder vote. You can't sell the company without a preferred stockholder vote. You may not even be able to, go to banks for lines of financing in excess of a pretty low amount without going back to a shareholder vote. Those get negotiated very early, again, at the time of the Series A financing, and you will live with that throughout the remainder of the company. Once they're in there, it's very hard to dilute those issues, and they go right to, control issues regarding the company. Oh, I can't. Fourth and final question. Who gets what if the company has a liquidity event? Extremely important for founders to think about. As I said, the liquidity events, while they can happen very quickly, within a couple years, it can go 7, 8, 10 years or longer for some companies. Again, without getting too technical on the jargon, in the event that the company is sold, there is a roadmap in the Articles of Incorporation that are negotiated very early in the company's history, usually at the time of it will be at the time of the Series A round, that talk about how the proceeds will be divided up between the common shareholders and the preferred shareholders. That section of the Articles of Incorporation is referred to as the liquidation section or liquidation preferences. In all cases, the amount of money that the preferred shareholders put into the company will be paid back to them first before any remaining proceeds are distributed to the common shareholders. That's sort of a universal truth. As Sam said, I think sometimes you can actually see that preference be 2x or 3x, but it's certainly going to be 1x. So if your Series A investors put $20 million into the company and you sell the company for $30 million, they get $20 million first, and the rest gets distributed down to the common shareholders. But then it brings up an extremely important question about whether the preferred is a participating preferred or not. If it is not a participating preferred, all of the remaining proceeds after the preferred stock has paid back their money goes to the common shareholders. If they are participating preferred, they kind of get their cake and eat it too. They get their money back, the $20 million in the example I suggested, and they also get to share side by side in any remaining proceeds with the common shareholders. If you run the economics on those two scenarios, they're extremely different and extremely, in a lot of cases, less beneficial to the common shareholders to have a participating preferred than not. Once that is negotiated into a deal at the time of your Series A financing, if indeed it gets in there, you never get rid of it. And it can change, the economics, dramatically going forward. And there are times when, it's in there and makes sense for it to be in there. But of all the things that, as Sam said, in the 10-page term sheet that you have to focus on, this is a big one. Dividends, less important. I'll just make a quick reference to the fact that most technology companies do not pay out dividends. It is becoming more and more common for East Coast kind of private equity type funds to insist on a cumulative dividend where for the preferred money that they put in on an annual basis, usually it's at an interest rate of like 8%, they will accumulate this dividend that isn't payable until such time as the company is sold, but then it's payable in full on a retroactive basis at that time. Well, you can imagine if you're accumulating 8% a year for 10 years on their money, that can add up to be quite a number. So that also can affect the economics quite a bit. And the final point I'll make is regarding acceleration of vesting. Most option plans, I'd say universally, perhaps all option plans, do not automatically grant vesting of unvested options at the time a company is sold. So for the average employee, their shares, either as part of the deal, to the extent that they're unvested, will either be negotiated to be terminated, or more commonly, they'll be assumed by the acquiring company and will continue to vest so long as that employee remains employed with the new venture. With respect to founders and other key officers of the company, it is not unusual to have change in control agreements that allow for some form of accelerated vesting in the event that the company is sold. You may have heard the terms, single triggers and double triggers. Single trigger usually refers to the fact that if you have the change in control event, namely a sale of the company, all the shares will accelerate. Double trigger refers to the fact that that event has to occur plus another event, which usually means that the person no longer serves in the merged company in the same capacity that he did in the prior company. If he was the CFO of the prior company and not the CFO of Google after Google buys your company, he accelerates. Those are very obviously key economic provisions for founders and ones that we focus on very early in a company's history, and you're well advised to as well. So with that, I guess my final thought again is foresight really matters. Again, these details are not the exciting part of the venture, nor should they be. And I'm a big believer that you as founders should be focused 99.5% on building a successful business, and the exit strategies will take care of themselves. On the other hand, these decisions that you make now will have ramifications that you have to live with for many years, and that's why I encourage you to get good advisors who do wrestle with these things for a living. So with that, I'll entertain any questions, and thank you.
Hi, so if I'm just getting started and I need to retain a legal counsel to deal with all these documents, I need to start a company and figure out ownership and IP and stuff, what should I look for in a legal counsel? How should I know whom to choose?
It's an excellent question. What I say when people come to me or I'm pitching them is, first of all, I think you need a law firm that can scale. You need somebody that can do it in a way that meet the economics of the startup, but at the time that you are Google, also has the capacity to handle the myriad of issues that will rise at that level that aren't at the startup stage. What I tell startups is you are absolutely right to think about not spending money on legal services too early in the company's history. I'll say, half the people that I talk to who are at the business plan level, and many of them I help, make introductions on financing as well, I'll basically say, look, you don't even necessarily need to incorporate right now. You don't need to spend the $10,000 to $20,000, which is generally what it takes to kind of get you going with your incorporation and your first set of board minutes and your option plan, et cetera. Put that off as long as possible. And until such time as you need to enter into contracts or otherwise have the protections of a corporation, spend that money on other things. So I think when I'm talking to a law firm, I would be really sensitive to the fact that they kind of get that they're partnering up with you, and on law firm economics, we make our money on the back end of sophisticated transactions. We're not trying to make the money on the Series A financing or the Series B financing. We're trying to partner with the company, grow along with them, keep their legal budgets under control so that we're there when the exit strategies happen, which is where our fees are generally made.
Hi, I have actually a question about immigration issues. I'm not sure how much you know about it, but basically, is it possible for somebody on an H-1B visa, on a work visa, to start a company or part-time, in their spare time or whatever it is?
Yeah, I'm not an expert on the visa rules. Obviously, it's a key issue in Silicon Valley, bringing in the talent to do that on a visa basis. It is possible to do that, but I won't kid you that it will be a significant diligence item to the investors as to the issues surrounding that visa and what the risk is that person may no longer be able to be resident in the U.S. It's a very complicated area. It will be, I won't say it's impossible, but it will definitely be a diligence issue.
Do you have any pointers, like who should I ask and what else?
I can talk with you offline about legal representation in that area. It's not the focus of what I do, but it certainly impacts our companies, and we have people that grapple with those issues.
Thank you.
Hey, so my question would be, as a founder, in a company open sourcing our software, what pitfalls have you seen in A, the fundraising process, and B, the acquisition process, whether it be early on or later, in a general term, irrelevant to the license specifically?
Haven't seen that as a huge impediment at all in terms of M&A interest. Again, in the whole technology space, whether you're open source or not, the first mover and market share advantage is far predominant in most plans we look at in terms of encouraging people what to do, rather than building up the barriers around the technology. That's obviously exacerbated by the open source. But people understand these spaces, and I haven't seen that be an impediment at all.
Okay, great. Thank you.
Okay.
What's your take on a startup investing money in filing a patent early versus working on a product? And as a startup, what's the strategy for minimizing that large upfront cost when working with an IP firm?
I'll paint with a broad brush here. For technology companies outside of the life sciences, biotech area, where I do think patents and patent protection is, for perhaps obvious reasons, more important. On the technology side, while patenting has its place, and we have a lot of patent agents, etc., it should take a second chair to moving forward on the business plan. Most of the companies that are seeking financing, as I said earlier, are moving ahead with their plans. The patent strategy is trailing that, and certainly it makes sense to be thinking about, particularly in terms of the global filings that are required now to protect your technology, to do that. But as you know, the time it takes to go through the prior art and to establish the patent is many, many years. And so we see that as generally a parallel strategy, but one trailing the actual execution of the company.
Okay, thank you.
Thank you.